Hello, everybody. Welcome to the 2026 San Diego Defense Lawyers Continuing Legal Education. My name is Cameron Cole. I'm going to be introducing our speakers today. Prior to doing so, I want to invite everyone to our first happy hour of the year. It will occur on March 19th at 5 p.m. at the Hidden Craft. That's at 600 West Broadway. And that's going to be at 5 p.m. And that will be a St. Patrick Day celebration. So we need you all there. Bring your associates, bring your friends. We know you can come. Today we are honored to have our guest speakers Ian Friedman and Amara Barbara. Ian Friedman is a California certified specialist in legal malpractice law whose practice focuses on professional liability defense, complex commercial litigation, and professional ethics. He represents both business entities and individuals in high stakes disputes, including attorneys and real estate brokers. He often secures early resolutions through strategic litigation, and beyond his courtroom work, Mr. Friedman served as the 2024 president of the San Diego Defense Lawyers. He is also an AV preeminent Martindale-Hubbell rated attorney. We also have Amara Barbara speaking today. She is a skilled appellate advocate and litigator whose practice focuses on complex litigation, specifically professional liability and business disputes. She handles matters in both federal and state courts. She has significant expertise in alternative dispute resolution, including mediation and arbitration. And prior to her current role at Rosing, Pott, and Straben, she was a consumer warranty and class action attorney, and she received her Juris Doctorate from the San Diego School of Law. Without further ado, I will pass it over to Ian Friedman. Ian, thank you so much for being here today.
Thanks, Cam. Thanks for having us. And Amber and I are both super excited to be here and chat through sort of legal ethics, which is everyone's favorite topic and just really gets people excited. So with that in mind, we had sort of designed this initially as a in-person drinking game, which is we thought would actually make people care about legal ethics. And this is just a slide where I get to show off my love of Google Gemini and its AI image creation. But we had thought about doing this as a sort of themed mock drinking game, and where we can sort of talk about the do's and don'ts of legal ethics, themed as a never have I ever game in support of trying to get Karen Perez's mission of getting people in person. But nobody signed up for the in-person happy hour, so here we are on Zoom, and you can all just drink over your Thursday lunch hour, and we promise not to tell as long as you don't work on client matters after doing it. So with that, we will move through our never have I ever's and sort of give you the scenario of what's popped up, and then sort of tell you why that isn't something that you should be doing in your practice. So Amber and I regularly defend lawyers in legal malpractice, and specifically in lots of defense lawyers, and lots of claims that touch on each of your practices. So what we try to do is go through and pull out sort of the do's and don'ts that impact specifically defense lawyers, and largely focusing on defense lawyers who work with insurance carriers in defending insureds under the tripartite relationship. So that's going to be a focus as we move through that. So without further ado, let's do the first one. First one would be, never have I ever disparaged a client or opposing counsel in email correspondence. I wish we were in person, because then we could have a show of hands of everyone who has done this before. But since I only have Cam to pick on here, Cam, ever happened?
Yeah,
Two.
all the time.
Don't.
No,
And Amber is going to tell us why.
I'm never the first asshole.
Well, I mean, let's just say it can get really colorful when you're going through discovery, and let's say you're going to get something in front of a judge, or you've got a topic that's, contested at deposition, or something to that effect, and you're in the trenches, you're getting that discovery prepared, and there's all kinds of stone throwing going on, and then you're looking into these emails, and even if the lawyer or client that you're defending, or the firm defendant that you are advocating for, has done a superb job of everything else, you are basically handing your litigation adversary, you're handing their opponent just some sort of little golden nugget to put in front of the judge that says, these people are going to lie to you. Look at how they actually talk behind people's backs. Look at how they actually conduct themselves. And it really paints a poor picture when what you want to do in front of any type of a tribunal, whether it's in arbitration in front of a judge, is, put your best foot forward. And so, as we discussed this, and again, with the context that this might be a fun little drinking game to play, we thought we'd bring up a couple war stories. And one that specifically springs to mind every time this type of an issue is raised was a very heated battle about what could be produced and what not, and what we could, keep from production to assist our client, because they had been doing a lot of this internal communication, kind of debasing not only the other counsel, but also their clients. And so we eventually got down to the point where we had to have a court order about the types of keyword searches that we needed to produce from emails. And some of those word searches started with B and were 5 letters long. Other ones were see you next Tuesday. There were quite a few very colorful phrases that we did have to actually go ahead and produce. And all in all, it put a bad taste in everyone's mouth, and it's an embarrassing thing to try to defend when you're putting that before a tribunal. So don't do it. Or, call up your friend and say, man, I had a hard day, but make it a phone call.
Yeah, I think one of the things that always jumps out to me about this is lawyers don't realize that their client has an unequivocal right to their entire file. And once you get into litigation, entire file means not only the external communications, it means all of the internal communications. And you can do the best job in the world for your client, but if you are calling them names, or you're calling even opposing counsel names in your internal email communications, those are going to be all the jury's going to talk about, all the jury's going to see, and they are going to make you look unprofessional. They're going to make you look unsophisticated, and they're going to make you look like a whining complainer, which is not what people expect of their lawyer. And it makes it, no matter how, it just undercuts, no matter how professional you look as you're sitting in there in your deposition or you're up on the stand testifying at trial, and all they're going to see are those emails where you're not that professional and you're not that polished, and they're going to think it's an act. And no matter what you say, if email, text, Teams message, Discovery will find it. You all know that because you all find it in cases that you litigate for your clients. They will find it, they will show it, and they will show it, and they will show it, and they will show it. So careful what you put in written communication. All right, next one. Never have I ever forgotten to send a case termination end of representation email. Um, oh, lost that one. Amber, you want to start on this one, or you want?
Sure, yeah. So, what we regularly see when we're defending clients is um, obviously that at some point in time someone's been sued, and if you'd like to try and dispose of that case at the earliest outset, whether it be the pleading stage, dispositive motion, you name it, having a real clear demarcation about when your representation ended is just, it's best from a client communication aspect, because now the client knows you're no longer being represented. I don't speak for you. I'm not filing anything on your behalf. I'm not taking on that appeal. I'm not taking on your post-judgment trial work, whatever it happens to be. So it helps you get that foot forward of, I'm no longer representing you. Secondarily, if and when there is a suit for malpractice, and you'd like to say raise a statute of limitations defense, you're going to need to be able to show definitively when representation ended, so that you don't have this open, vague, kind of easily, artfully pleaded around period of time wherein they can say, oh no, I thought I was still being represented. And so you've got continuing representation, extending your tolling there. You may have other acts that occurred or did not occur, acts or omissions in that post representation period that now, at least at the pleading stage, can fall on your firm or on you personally. And so it's just the best case scenario to always make sure to send that clear termination letter, discuss any next steps. If that needs to be about payment or if that needs to be about seeking another attorney to discuss post-trial work, appeals, whatever, what have you, put it in that detailed written agreement at that time.
I think the second part too that you can really emphasize and a real reason for going forward with the termination letter is going back to the client file. So we all know clients have an unequivocal right to their file, like I talked about earlier. And when you are transitioning off with a matter, if you're running a firm, you know that storage costs if you're keeping hard copy files are immense. Even if you're keeping digital files, you have large storage costs there. So you want to be real clear, give the client a real clear demarcation of what's happening with their file as you're transitioning off the matter. I know there's a lot of firms in town who will keep paper copies of their files when the matter is ongoing. When it's time to transition off of the matter, they scan the paper files into an electronic database, and you need to tell the client that. And you want to make sure that you're putting that in your termination letter of we're closing our file, we're transitioning to an electronic file, we're scanning everything in, and give them time to let you know if that's not something that they're okay with doing. And if they want a copy of their file, you give them a copy of their file at that point. The other thing too, from a conflict analysis standpoint, as you're taking on new matters, it's really important to know whether someone is a current client or a former client, because there's different standards that apply in terms of what matters you can take on. So obviously you can't be adverse to a current client, but if you're taking on a new matter that's potentially adverse to a former client, then the test becomes whether the matters are substantially related and whether there's an overlap between the two. And you need to know whether someone is a current client or a former client. And if you haven't sent that termination letter, your accounting department, your conflicts department, however that process works within your firm, may not know what the demarcation is and may not know how to process those new incoming clients. And one of the biggest things I think that and we'll talk about this on some of the other topics as we move forward, in terms of analyzing and defending claims against lawyers and putting yourself in the best position to stay out of court and stay out of being a defendant. One of the strongest I'll call it shields that lawyers have that a lot of other professions don't is a 1-year statute of limitations. And 1 year comes up really fast on potential claimants. And the sooner you can start that 1-year process, the better off you'll be. And you want to give the court, as Amber touched on, you want to be able to have that clear demarcation of, no, it's February 18th, and they sent a letter and said the representation was terminated. There is no question of whether you're following up to get your bills paid or whether you're following up to transfer files. They said on February 18th, the representation is done. And a lot of times when you're dealing with a short 1-year time frame, days matter, weeks matter. And what you don't want to do is have the representation continue to creep forward because you undercut your potential arguments down the road. All right. So our next one sort of builds off of that last topic, and which is why we put them one behind each other. And so the next one is, never have I ever represented multiple clients without a conflict waiver. Conflict waivers and come up sort of in the context of whenever you have multiple clients who are on the same matter or different matters if there's a relationship between the two matters, and there is the potential that a conflict could arise in the future. And so many times we see, and Amara can talk on this too, is you have lawyer who just was trying to help everybody, and got involved in a matter, and maybe they took on the company first, and then all of a sudden there's a client who's or an employee of the company who's getting deposed, and you step in and you say, no, we'll defend that employee deposition, even though that's another person, and we'll represent that employee. And when the employee comes time to testify, he bashes the company. And now you're in a position where you have your two joint clients who are uh, diametrically opposed in terms of what they're advocating, in terms of what they're saying, in terms of how they're conveying that. And you, as the lawyer, are stuck in a situation of what do you do? Who is your, well, the company is paying your bills. They're the ones that hired you. But at the same time, you owe the same duties to uh, the employee of the company. And because you got the file assigned to you from an insurance company, you probably didn't have a retention agreement directly with the insurance company. So it never even occurred to you that now you have these two separate conflicting representations. So even it's really important, I think, specifically on the defense side, because you're oftentimes not having retainer agreements with the insurance carrier. The file just comes in, and it just sort of goes. But you need to always be on the lookout for the potential that a conflict could arise if you're being asked to represent more than one person. And what those conflict waivers look like is they need to be specific. You can't just have a general conflict waiver that you use on all of your files, that you just throw out there. It's the same one you use every time. You need to actually put some thought into what those potential conflicts could be. And this is actually a good one if you want to drink at night, because you can be as creative as you possibly can be in terms of evaluating what those potential conflicts could be. So put some time into it. Sit there, think through, well, what could happen if this person testifies this way, and that could create a conflict? What if there's a dispute over how to proceed? What if there's a dispute over what settlement looks like? Sometimes you have clients who are interested in non-monetary resolution versus monetary resolution, and there's other terms that might be beneficial to one person that would harm another, and in terms of steering the litigation and how to proceed with that. So really put some thought into it. And the more meaningful your conflict waivers and more thoughtful your conflict waivers are, the stronger position you're going to be in. The other thing that you always want to put in your conflict waivers is make sure to advise your conflicting clients of their right to consult with independent counsel. And I wonder if Amara's experience is any different than mine, but 99% of the time you tell someone to consult with independent counsel, they are not going to do it.
Right.
Nobody's going to do it. Nobody's going to follow that instruction. But it is, as far as silver bullets go in terms of protecting yourself on a potential conflict claim, the giving them the advice to consult with independent counsel, whether or not they agree or do it, whether or not they move forward with it, whether or not they even read the sentence, as long as it's in there in bold, highlighted for them, you want to make it puts you in the strongest spot to protect yourself in the event that a conflict would arise.
Yes. And we do typically, when we send these out in our own practice, obviously Ian and I both work in professional liability at Rosenblatt and Strobing. We will not only put it in the conflict waiver, we will then send a specific conflict email that also has that recommendation. We'll normally say, take some time to think about it. We'll give some sort of a duration, whatever it happens to be. And with an underscore, you don't need to get this back to me today, seek independent counsel if you need it. And so we have kind of that dual layer of protection. And then adding again to his point, the better the specificity, the better you are protected. So feel free to circulate that conflict waiver to someone else inside your firm. Think, is there another way that this could go sideways? Is there another way that they could become adverse to one another? And I mean, put it in there. So it doesn't hurt in this situation to be expansive.
Amara, in your practice, do you send the conflict waiver at the start when the file comes in? Do you send it, and then do you just stick with that conflict waiver the whole time, or are there certain circumstances that'll come up where you end up updating it if something new changes, or how does that, what's your process there?
Yeah, generally, at the outset of a case, that will just be one of kind of the case initiating documents that we will send out when, especially as you already mentioned, if you have a company and an employee within that company, especially if you have a company and a former employee of that company. Also, this does tend to arise when you've kind of gotten into the details of the case, you've gotten through discovery, and now you're at depositions, and things are kind of starting to arise on the facts that maybe you had not contemplated before. It's important you can reissue that same conflict waiver. Given that we've realized that this document came out in discovery and that there's testimony from X player who said why we are sending this conflict, because now we've highlighted and we've recognized and evaluated back and forth that this could also be an issue. And so we are going to review once again your right to have independent counsel take a look at that waiver and make sure that you are still comfortable being represented by the same attorney. And I think you do have this in the slide, Ian, but also you want to make sure in the event of a conflict, which client you're going to keep. And so I'll take that back over to you, Ian, but I think that's also a really important and key provision of these waivers.
Yeah, it's very important because you want the clients to know, not that one is more of a main client than the other, but what you don't want to do is end up in a situation where you don't have a waiver, you now have a conflict, and you're out on both clients, because there is no privilege between joint clients, which is another thing to include in these at all times. And so when I draft a conflict waiver, we'll make it very clear, for instance, if we're using the employer-employee example, that in the event that a conflict arises, we will continue to represent the employer, because you take the main client, and then the employee would need to then go find independent counsel. And you have them waive that ahead of time. You disclose that ahead of time, and you make sure that that's known to everyone going in. Again, with the advice that they consult with independent counsel before agreeing to it. But it's just so critical. There was a question in the chat. It says, do you need a conflict waiver if you're representing two defendants and one of them is under the policy of the other? For example, if a doctor has a nurse practitioner under his policy and both are sued in a med mal case, do I need to obtain conflict waivers for each? Answer is yes. Both being under the same policy doesn't really determine anything, because you still have the same positional conflicts that could arise where there's not. The policy may say that maybe, for instance, the insurance company controls settlement or something like that. But that's just sort of one issue. There's still the potential that nurse could testify that doctor did something wrong, or doctor could testify that nurse did something wrong, and then you're sort of in a positional conflict at that point in time where one's pointing the finger at the other, and you don't want to be the lawyer in between there. Oh, this is one of my favorite ones, so I'm going to take this one first. This next one is never have I ever used my work electronics with client data on public Wi-Fi. And I would love to take a poll on this because I think 80% of people have probably done it. And it's really dangerous. It's really dangerous. Law firms are a massive source and target for hacking these days. I think we're all seeing all sort of methods of scamming, phishing, whatever, any way that someone can get your data, they are trying to get your data. You all have in your client files and your emails, you have tons of social security numbers, I'd imagine. You have tons of private personal data. You have tons of information that hackers could do a lot of damage with, bank accounts information, tax returns, all that stuff. And so law firms are, historically, probably a weaker link in terms of the data privacy. And, there's all sorts of avenues that you can get attacked on this stuff. And so both the bar, in terms of the COPRAC, the professional responsibility group within the bar, and the bar have been very active in terms of advocating, especially in a remote work setting, the need to ensure that you are complying with your duty of competence and duty of confidentiality to your clients in terms of instituting appropriate data privacy protections. So it's really, really important. I think we always advise clients you should not be joining public Wi-Fi, especially in an unprotected setting. Like Starbucks, for instance. You go in Starbucks, you don't know who's sitting there, and it's going to hack your data. And if your data gets hacked because you joined a public Wi-Fi, you not only breach your duty of confidentiality to your clients by exposing their data, you also, competence issues, that sort of thing. And so, and what the test is the rule is you have to use reasonable measures to safeguard confidential client information. And how they've come out on reasonable measures is putting in place appropriate data privacy policies, procedures, practices. So updating your passwords, using two-factor authentication, not having your password be 123 4. And one of those other things that comes up is not using public networks. And not exposing your client's data to public networks. I think it's very easy to have personal hotspots. So I know whenever I'm traveling, I always use my phone, the personal hotspot on my phone. It's the only internet I'll connect to. Most of I'm sure your firms probably pay for your electronic devices, your phones. You get some sort of reimbursement. As a firm policy, you should be requiring that all of your lawyers, who, especially if they're getting reimbursed for their cell phones, are only connecting to private Wi-Fi via a hotspot or other private data source.
Ian, does that apply if your firm has a VPN, or are you safe if you have a VPN?
I still wouldn't put even a VPN on a public Wi-Fi network.
Okay.
Yeah, I mean, you're just sort of inviting danger.
Okay.
Another good practice too is to make sure, and I know we all have so many passwords that we have to keep in our head, but make sure that to the extent you use any passwords with work email, work systems, any type of password, that's not the same type of password that you use on any personal accounts or information, because generally speaking, if there's going to be a data breach and they do get a hold of that password, you don't want that same my dog ran to be the way that you get into your work access. So make sure that those are distinct.
And one of the things in terms of liability for law firms too, that this sort of data privacy stuff is really terrifying with is we're actually seeing an uptick in class action lawsuits against law firms. So it's not you did something wrong in my individual case. It's your database got hacked. All of your client data was exposed. You have breached your confidentiality obligations to all of your clients. And think about all of your clients as a lot of clients. So it's the same confidentiality obligations and it's the same data breach potential liability that every other firm or every other business sees. And they're coming for law firms because they know lawyers have a lot of emails. They click links relatively easily. Staff don't tell them, but staff clicks links relatively easily. And you just risk exposing the firm yourself to liability if you're not careful in terms of how you're maintaining your data privacy issues. And the other thing too, before we jump off this one, if you're a managerial lawyer, it's your responsibility to put in place these policies and procedures to protect the data. It's your responsibility to make sure that staff, other partners, associates are all following these appropriate practices because both the managing attorney who's supervising the firm, putting in place policies and procedures, and the person who gets hacked risk potential both liability, state bar investigations, all that fun stuff. So again, reasonable measures with the sort of the availability of private Wi-Fi networks that you can put in place. That's sort of the base standard, right? And so hotspots, that sort of stuff. And as long as you're taking reasonable measures to protect your data, that's a good starting point. But the more you can do, the better. All right, next one. Never have I ever sued a former client for fees prior to the running of the 1 year statute of limitations. Amber, you want to jump off on this
This
one?
one, my favorite. This has got to be, at least from my practice, I'd say one of the foremost reasons that attorneys get sued. And it is just not waiting to collect your fees after maybe there was an adverse jury trial determination, maybe, there was a falling out for whatever reason at the end of the representation. The client stopped paying their bills and everybody wants to get paid, and so you sent all of the letters, you gave them the opportunity to correct, And then 8 months later, you go ahead and file that, breach of contract, cause of action. And the mandatory cross complaint that I guarantee you will get is professional malpractice and breach of fiduciary duty. It happens almost every single time without fail. And the problem is that had you waited, because again, your contract, your breach of contract cause of action has a 4-year statute of limitations. Your legal malpractice cause of action has a 1-year statute. So you're not at risk of losing out on recouping any of that loss by just simply waiting for the 13th month to file your claim. But the trap that happens is you lose out on that statute of limitations defense. And then in addition, anytime that that complaint is amended, they add additional allegations, everything's going to relate back and none of it is going to be time barred. And so you can be in a situation where maybe this representation happened 6, 7, 8 years ago. It doesn't even matter at this point in time. You can't get rid of it. These claims are stale. And you're running up really high cost of defense at this point in time for something that you could have done away with at the pleading stage. In addition to that, if you wait until after the statute of limitations has actually expired, all they're entitled to is offset. So you have the additional, tool in your handbook of getting able to cap those types of damages in addition if you've waited. So really, really, really drive the importance of that home. I know everyone's accounting and HR team, everybody's going to be on you to get that client to pay the bill, but really when in doubt, just wait that a little bit extra time, set yourself up so that if and when that complaint does come, you have the best defenses available.
Yeah, and this is one of those situations where we tie it back to the termination letter too. And you can explain this to your accounting folks, and you'll be your accounting folks' best friend. You send your termination letter, that's a clear demarcation date. And if you know there's an outstanding balance, you've sent your termination letter on February 18th. You can have your accounting people calendar February 19th of next year as your date for filing your breach of contract case if you can't get your outstanding bill paid. It's just the potential of waiting is so. I know everyone wants to get paid. I know everyone wants to jump out, and you feel wronged because you've put in all your time, and the way lawyers are paid is your bill your hours. You wait to the end of the year. You see what hours you billed. You see what hours you've collected on, and there's an incentive to try and get that money in before the end of the year. You're buying yourself a lawsuit almost every time. You sue a client for fees, you will get sued in return. I think one of the biggest things that we see in terms of lawsuit triggers almost throughout all of our cases is attorneys running up big bills for clients and letting balances carry forward. It almost always they end up getting sued. And you could have done good work. You could have communicated with the client constantly, which is why you ran up the big bill in the first place. But if you have a 6-figure or even a mid to high 5-figure amount where your client owes you at any point throughout the case, and if that balance just keeps accruing and you keep doing work because you have to keep doing work to protect the interests of your clients, the larger the balance, the more likely you're going to get sued. Because they ran up the balance for a reason. They got your bill every month. They ignored it. They didn't pay it. And the fact that you continue to represent them, they're taking advantage of you. And when it comes time to collect that bill at the end of the representation, or whenever you send them your invoice 30 days before trial, and finally send we're not going to represent you and take this case through trial unless we can get our bill paid, which I'm sure most of you have sent. You're going to draw a claim. You're going to draw a lawsuit. You're going to draw an abandonment claim. They're going to say you're breaching your fiduciary duty to them because you care more about money than anything. And they are not going to care that you haven't been paid. And they will fight to the death and litigate it to the end of the earth to avoid paying that bill. And the other thing too is just the reality of it is even if you sue for fees, even if you end up being owed a significant amount of money and the malpractice claim comes as a compulsory cross complaint, there is the majority of the time, and Amber, I'd be curious on your experience with this, but the majority of the time those cases end, they either go to trial and you have dueling judgments, or not judgments, but dueling findings. So you have the malpractice claim and the breach contract case, or they end up resolving, and the almost always the demand from the other side is walk away on the fees. We'll forego some of the malpractice damages if you walk away on your fees, and then you're stuck in a position where your carrier on your malpractice stuff is saying, "Well, we'd love to settle this case," and you're saying, "Well, I'm not walking from my fees," and then you have the immediate pushback and the conflict with your carrier in terms of what that does to your policy.
Oh yeah, I mean this absolutely snowballs out of control. We see it happen all the time. This is when you have to get, Kuma's counsel coming in. You've got you can have a bad faith action come out of this. You can have a hammer clause from an insurer who's absolutely sick of it and says, no, you either settle or you carry this on your own. Not to mention the vast majority of insurers that I know and that we work with, they're not going to allow your malpractice counsel to prosecute your fee claim for you. So you're already going to be carrying additional costs there. You've got premiums that are now going up. I mean, it seriously does. It gets pretty ugly pretty quickly. And Ian, I'll kick this back to you. How often have you actually seen one of these claims get paid, truly? Even if you do end up with that type of a judgment, now you're talking about collection. There's a reason probably that your client wasn't paying you in the first place. And unless this is a company that has the ability to satisfy that debt, that's another calculation to make. So really do think about the downstream effects of not only when you file this claim, if you need to file this claim, make sure also that you're providing that client the notice of the right to a mandatory fee arbitration. That I've actually seen go a little bit better for a lot of firm clients to go that route instead. Also, a lot of insurers will actually allow malpractice counsel to represent you in a fee arbitration. And so that's another route that a lot of firms are starting to take as well, because again, it's just so difficult to get paid and there's just so many negative potential consequences that do come up regularly. It's just the most common fact pattern that we see.
Yeah, and it's almost always going to draw a lawsuit, almost always. And a lot of those, the reason for the never have I ever, those downstream consequences are so much less if you wait 13 months. Wait until the statute's expired. You're in such a much better position, and really then all they can argue is that you didn't do as much work as you said that you did. And you litigate that, and you come out to you find out what that answer is, but you're then at least not having the malpractice claim against you, and you're not in a position where you're paying them money. It's just you may or may not get the money back from them. So definitely wait the 13 months. No matter what your accounting department says, tell them they're saving money by not litigating right now.
Absolutely.
All right, this is a two-part one. Never have I ever communicated an important event only to the carrier and not to the insured, or the inverse of it. Never have I ever communicated an important event only to the insured and not to the carrier. Amory, you want to start with this one?
Sure. This is, again, one of those very common fact patterns, and these issues come up strategically, especially when you are dealing with this tripartite relationship, which I'm sure we're all familiar with. But every single update needs to go to your client and then also to the carrier. In addition to this, every single time there's a strategic decision that needs to be made that might implicate either one or the other, that same email needs to go to both. Now, to the extent that your insured and your carrier is in lockstep or they have a good relationship, by all means, feel free to throw them on the same email so that everyone can see that, transparently, I'm getting the same communication that you are. This comes up often in anticipation of mediation or some type of settlement discussion, wherein there may be a difference of opinion about what a likely range should be, whether or not it should be settled. You could have a firm that really wants to get their fee claim resolved and they don't want to compromise the fee claim. And so now you've got kind of an issue going on already between the carrier wanting to get rid of this complaint, the firm not wanting to compromise their fee claim, the difficulty in between. You have to make sure that your communication is explicit between both, pros and cons of both. And in addition to that, any type of conversation that you have with your client that the carrier needs to be made aware of, you should do that in a way to ensure that you're actually still maintaining your duty of loyalty to the client and ensuring that their representation is being carried out for their advantage and not because the carrier is telling that you need to do something. Conversely, right back the other way. So when there is a type of strategic tension between what one part of that relationship wants to do, you need to inform both of it. And honestly, this is a CYE email for you as well, because once you've told everyone what's going on behind door one and door two, they can't now point at you, door three, and say, this is the reason it didn't get settled. This is the reason that we went to trial on this. This is the reason that we lost. Because you kept them informed as you're required to do at every step of the process. So don't forget to just be the arbiter, the messenger in between both sides if there starts to become a tension, and also recognize when you might need to pull that parachute string and kind of get out and say that independent counsel needs to come in and make sure that this is handled appropriately before you have bad faith claims going back and forth between the client insured and also the insurer.
Yeah, I think so. Suing your client for fees is a big thing that will draw a malpractice claim against you. The other huge one, and I would say maybe even larger, is the failure to communicate. And when you don't communicate with your client, when you don't communicate with the insured, when you don't communicate with the insurer, people don't know what you're doing. And you can be working all day long, doing everything you can to advance your client's interests. But if they don't know what you're doing and they don't know that you appeared to argue a motion for summary judgment, and they don't know that you lost the motion for summary judgment, or they don't know if you won, and they don't really care if you don't tell them if you won, because then they're not going to sue you because you won. But I mean, if you don't tell them what's going on in their case, and you don't tell them we're coming up on trial, and you don't tell them we need to disclose experts, and you don't tell them who you disclosed as your experts, they don't feel that you're being truthful with them, and they don't feel that you are doing what you've been hired to do, and they start questioning things that you've been doing. And even if you're doing everything right, the minute a client starts questioning you, I think everyone's been in that situation, it's just sort of a downhill spiral from there. And they start pushing back on why you're doing things, what you're doing, how you're doing, and you just open the can of you're not communicating with these people, and they're going to have questions, and they're going to sue you if things don't turn out, because they're not going to feel like they were a part of the process. Clients want to feel like they're a part of the process. They want to feel like this is their life, especially insureds. While they may not be paying your bills, this is their life. They're being dragged through a lawsuit. They're exposed sometimes to excess liability. Um, they want to know that you have their interests in mind and that you are there to be their protector, to make sure that they're being cared for, to make sure that they're being protected. And the only way that they know that is if you communicate with them. I think we are seeing it's almost shocking the number of insurance carriers that are starting to sue their panel defense counsel. And I know a lot of times as defense lawyers, you sort of view those panel defense counsel relationships as those are your clients. They're the ones who send you the business. You're not getting sent the business by the insured. And you know these carriers, you know the carrier representatives. But as the carriers are getting exposed to more and more excess judgments, as they're getting exposed to more and more excess contractual liability claims, they're looking for someone to blame. And it's probably not the adjusters who you know and love, but there are pressures coming from higher up in the insurance companies that are forcing them to look to defense counsel as basically guarantors of the legal claims. And because you can't assign a legal malpractice claim, the insurance carriers are saying, hey, if we're on the hook for an extra contractual liability claim, if someone's claiming that we engaged in bad faith, which caused our insured to be exposed in excess of the policy, hey, defense counsel, you're the one that we hired to protect this. You're the one that we hired and gave 2 minutes of notice to accept the time limit demand before the case even got started. You should have done better. You should have jumped in on that quicker. You should have explained to us the risk of not accepting the time limit demand prior to the start of the case. And if you are there saying, yeah, but you told me to just send them a letter, or you didn't tell me to accept it. unless it's in writing, it's not there. And unless the insured knows about it, it's not there. Unless the insurance carrier knows about it, it's not there. And a lot of times the insured will feel that maybe the defense lawyer was trying to protect the insurance company, or the insurance company will feel that maybe the defense lawyer was trying to protect the insured. And so the more you can keep everyone a part of the process, you really just keep yourself. One, you get better results from your clients, I think, because you get better buy-in. They understand the process. When you finally get to mediation, they know what's been going on. They know how we got here. And it's not news to them, right? And so you just keep people engaged in the process and you protect yourself along the way. And you never want clients to not know what's happening. And I think honestly, best practice is I like to copy the insurance company and the client and the insured on every email that I send. I know there's some things that the insurance company doesn't want to know about. They don't need to necessarily know like deposition preparation, scheduling, and that sort of stuff. But major events, you appeared at a hearing, tell the client and the carrier. You appeared for a motion, tell the client and the carrier. You want to hire an expert, tell the client and the carrier. And if there's disagreement between the two of them, let them figure it out. But just make sure that everyone's in the loop, and you'll be in a safer spot because of it.
Yeah, I completely agree. I was just going to add, just, this is really simple to work into your everyday practice. Pleadings come in, you send them to both. You've got some sort of a strategic decision to make. You let everybody know this is the decision that I'm contemplating. Here are the pros and cons of it. We're advising that we do this. Do we have your buy-in? Do you want to set a time to discuss it? There are obviously reporting guidelines for carriers that you need to adhere to as well, but really those are just benchmarks so that they're ensuring that the case is getting moved forward. You need to be doing more than that. Those day-to-day correspondence about, we just served written discovery. This is when it's expected. Okay, we just got the written discovery. Here's what we found out. Now we're going to move to set up these depositions. Are there any others that you're interested in setting? I mean, just little touchstones like that throughout the lifetime of a case really do go a long way. It does improve the relationship with the client, and it also makes it much more difficult for them to turn around and say, I didn't know why you did that, or I can't believe you did, or what's all this billing about? Because they've been kept reasonably informed as you're required to do. And just the last point on that, don't assume that keeping a client reasonably informed comes in the form of your bill when you send it. That is not keeping the client informed of the status of their representation. So just talk to them as the case progresses.
Building off of that, next one is never have I ever failed to document a discussion regarding the pros and cons of a litigation strategy. Amara, since that's where you were, you want to keep going?
Yeah, if it's not in writing, it didn't happen. I mean, it just didn't. If you say that you spent 20 hours researching, I don't know, some topic, and you don't have a memo about it or an email about it, or your notes as you were researching, that research didn't occur. If you said that you called the client and you discussed whether or not to settle at $500,000, but it's not contemporaneously written down, there's not an email confirming it after, and everything that you discussed, the conversation did not occur. As far as just about anyone is concerned, that is going to be the argument from the other side. Even though it might be in billing records, discussed settlement with client, it's just not going to move the needle that much. So ensure that every single thing that happens on that case, especially when it's a strategic decision that needs to be made, is well documented. Whatever conversation with the client occurred, well documented with the insurer, well documented. Write another note to file, write another email to co-counsel on the case about what was discussed and the reason that you're doing whatever it is that you're doing. Because truly, if not, it just didn't happen.
Yeah, and one of the big, I mean, bills are helpful, right? So you're having something in your bill is helpful. It tracks your time. I'm a big proponent of, even if I know carrier guidelines are pretty strict in terms of what you can bill for and what you can't bill for. If you're doing something on a case, it should be on a bill whether or not you can bill for it, because it keeps track of what it is that you're doing. Even if you have to no charge it, bill it. Put it on the bill and no charge it. It helps, one, with client relations, because you're showing them, hey, we're writing off time when we're supposed to. But two, it gives you a detailed timeline of what exactly you were doing. So uh, it's always better to have it on a bill because then you at least have it in a writing. Where I think one of the dangerous things and why it's so important to email and communicate directly with the clients and not just leave it to the bill is I know there's a lot of you who work on flat fee billing arrangements. And there's a just an inherent tension if your firm internally isn't necessarily tracking, the amount of time that goes into it for your own internal metrics, which I know a lot of people do. But if you're not keeping track of those metrics and you're not really doing detailed billing like you normally would because it's just a flat fee arrangement, um, your bill isn't going to be as strong. And so even if it takes you an extra minute or two to put in the time on describing your tasks, even in those flat fee billing arrangements, you still then have something tracking showing exactly what you did. Always best practice to communicate with your client in a writing. Tell them, hey, we discussed this. Obviously, you don't want to beat them over the head with the memorialization email, but have something documenting the discussion. Even if at bare minimum it's a bill, a bare minimum a memo to file. Sometimes I'll write a memo to file and send it to the client and say, "Hey, great catching up. Just for your information, here's the memo to file I just did on this." Just so they have it, so there's something, so they can communicate to it. And then when they don't write you back and say that's not what we discussed, the fact that there's no writing on it, they can tell you later that maybe we didn't discuss that, but same thing works in reverse. If it's not in writing, it didn't happen. And so if the only writing exists is your memorialization of what you discussed with the client, that's going to be what's going to govern. And 9 times out of 10, if we're in a malpractice case and we're now 2, 3 years down the road, they're not even going to remember the discussion. And the only thing that's going to exist is going to be your memo in the file or your email or your billing record that's going to show that that discussion happened. And as long as your bills are truthful, they're accurate, the more detailed they can be, the better, and the stronger position you're going to be in.
Yeah, and forwarding that correspondence too is a great way to facilitate that transparency between you and your client when you have that tripartite relationship. So forwarding them, hey, we discussed this, and this is the email that I sent to your carrier on it, or this is the report that's going out to your carrier. Do you want to have any input on it before I send it? Things like that really do help as well.
All right, this is my favorite one, and I could do like 7 hours on it, but unfortunately, we only have 8 minutes. So here we go. And also, this is just another example of me getting to show off my AI generation, image generation skills because that's fun. So never have I ever used generative AI to draft a brief without site checking. I am sure that hopefully everyone on the call or watching the video later has heard of the dangers of AI. And I know we all are sold consistently the benefits, the efficiencies, how this is life-changing and game-changing. Some of that maybe is true. But at the same time, there is real danger, both to your clients and in your own self-interest to you, both from a malpractice and a regulatory standpoint in using generative AI. It is dangerous. I can't stress enough. It is dangerous. It is dangerous. It is dangerous. We are going. Yeah, I mean, it's at least once a week. We're getting phone calls from a new lawyer who has filed a brief that had a made-up citation in it. And people are thinking that this is the greatest thing ever, and it is getting people into trouble. Regulators are paying attention. There's active legislation that's being proposed to try and regulate how lawyers use AI within their practice. This is a real danger. And if you're not on top of it, and if you're not checking your citations, you will get caught. You will be subject to bar investigation, and it's going to hurt. We haven't seen the sanctions coming down yet from the California bar. They're still, the initial ones are really working their way through the process, but it is going to hurt. Courts are making it hurt. There's a sanction that came out of, I think it was either Texas or Georgia, where a judge made a lawyer send a letter to every court that he had ever appeared in throughout his entire career, advising that he had been sanctioned for using generative AI. This
And
was
each of his clients.
Oh, I was going to get there.
Yeah.
And each of his clients. So every court and every client who this lawyer had ever worked with had to get a letter from this lawyer saying that they had been sanctioned for using generative AI. It is a real concern. And the hallucinations aren't just sort of one easy definable thing. And so it's sort of described it as big H hallucinations versus little h hallucinations. Big H are the easy ones that we hear about, right? It's ChatGPT made up a case, I filed it. It made up a record site, I filed it, I didn't read it, didn't check it. The little h are the harder ones because it's a real case. It'll give you a real case, and sometimes it'll even give you a real quote, but it'll quote as the holding what the trial court said, which was reversed, or it'll make up a holding, or it'll misinterpret a holding. So you just have to be so careful in terms of checking what it is that you're filing with the court. And and the AI stuff is a balancing test too. It is, as the technology gets better, we are going to start seeing competency claims against lawyers for not using AI. Because it does create efficiencies. There are things that it can do to help move your practice forward and save your clients money. But I don't think that we're there yet. I think there is still real danger in this, and the danger exists regardless of whether you're using ChatGPT or whether you're using one of like the closed loop systems offered through Westlaw or Lexis or whatever other research programs are out there. You can still get the hallucinations, you can still get the missed sites, you can still do just land yourself in a whole lot of hot water. So what can we do to protect yourself in terms of preventing, getting caught up in the AI stuff? Check your citations. One, the Westlaw and Lexis both offer the site checking programs where you can upload your pre-filing motions or opposing counsel's motion in there, and it'll tell you whether or not the cases are real. That is the bare minimum in terms of what you should be doing. And this, I think, where it really comes into play is if you're a supervisor, if you're using a brief that someone else wrote, if co-counsel wrote a brief and you're signing it, co-counsel wrote a brief and your name is even on it, even if you don't sign it, check it, because you can be just as liable as the person who used the ChatGPT to write the brief. If you're the supervising lawyer and your associate gives you something, I would ask them if they use any AI in there, and you should have firm policies in place that ensure that AI is not being or if it is being used, that it's being used appropriately, that people are site checking, that they verify that the citations they're submitting are correct and accurate. And just remember that AI can never replace professional judgment. It is not a lawyer. It is not intelligent. It is a sentence finisher that just takes whatever data you put into it. It makes some things easier, but it is not a substitute for lawyers. It's not a substitute for your own professional judgment. So just be really cautious. And like I said, I could go on AI for a year and a half, but Amber, anything to add on
Oh
that
yeah,
as we come up?
the most recent horror story that we've been made aware of is just actually one of these hallucinated citations were actually populated through Lexis. And so even if you're using just the search engine to start off with, make sure you're clicking through, you're actually reading that case, you're actually checking the site, and that it says what it says it does. Because there's also more sophisticated hallucinations, like Ian was discussing, where it's kind of a Frankenstein site. It might take the theory or the holding from one case and then it'll attach it onto the citation to a different court. And they do look real. They do sound like they are. And so they really do need to be checked. And again, even through Alexis or a Westlaw, if it populates it, make sure you're reading it. And I'll add to it, it's going to become more pervasive. The more that these citations, the more the AI is used, there are going to be more and more of these hallucinated sites out there. So it's going to get even trickier to someone who's not had taken the time to actually review it.
Yeah, and there's a great comment in the chat too of no, and this is one of those things I cover all the time if I had longer than 8 minutes on AI. But AI is not private. It's learning from your data. So if you're using an open sourced ChatGPT, Gemini, Grok, whatever, is learning from your data. And the minute you put client confidences in there, you're disclosing client confidences and allowing it to learn from that data. So be really, really careful in terms of what you're putting out there. But we are right at the hour. So unless anyone has any questions, obviously we'd be happy to answer those. But just thank you very much. And it's great getting to speak with everyone. And maybe next time we'll do it in person.
Thanks, everybody.
Thank you, Ian and Merritt. Great presentation.
Awesome. I don't see any questions. So thanks, guys.
All right, have a good one.